High voltage sign employers, beware, a single phrase in your employment contracts could cost you tens of thousands, and most companies don't even realize it. But here's where it gets controversial. Courts can't seem to agree on whether using phrases like "at any time" in termination clauses actually breaks the law. Recently, Ontario's Superior Court once again ruled that including the words "at any time" in a termination provision contravenes the Employment Standards Act, 2000, ESA, making the whole clause unenforceable. In Chan v. NYX Capital Corp., 2025 ONSC 4561, the court sided with the employee, holding that such language rendered the company's entire termination clause null and void, despite similar cases where other judges reached the opposite conclusion. Let's break it down. In this case, NYX Capital Corporation, a real estate investment firm, fired Reginald Chan just 1 day ahead of the end of his 3-month probation. Their contract let NYX terminate at any time and for any reason, with no notice or severance. NYX assumed this airtight clause protected them, but Chan challenged it in court, arguing it violated the ESA and thus entitled him to common law notice compensation. The employer disagreed, confident in the contract's wording. So, what did the court find? The judge determined that the phrases "at any time" and "at any time and for any reason" gave NYX more power than the ESA allows. The ESA specifically prohibits employers from crafting contracts that remove or reduce employee rights below its minimum standards. The law protects employees from unfair dismissal, especially if they're being punished for exercising legal rights. In simple terms, even if a contract seems clear, if it undermines ESA rights, even inadvertently, the contract clause is invalid. And this isn't the first time. Earlier decisions like Dufault v. the Corporation of the Townships of Ignis, 2024 ONSC 1029, and Baker v. Van Dolder's Home Team Incorporated, 2025 ONSC 952, also struck down the "at any time" language, while other cases, including Jones v. Strides Toronto Support Services, 2025 ONSC 2482, took the opposite view, suggesting such vacancy language might not always void the termination rights completely. This split in court decisions stirs up a lot of debate. Should contract clarity reign, or should courts always err on the side of employee protection? In the Chan case, the court leaned heavily on earlier guidance from the Court of Appeal, Waksdale v. Swegan North America Incorporated, which established that just one clause breaching ESA standards can topple an entire termination section. As a result, NYX's mistake cost them dearly. Chan received about $45,000, far more than if the contract had followed ESA requirements. Here's the takeaway. The language you use in your employment agreements matters tremendously. Employers must review every clause with a legal expert familiar with the ESA. Otherwise, a seemingly small oversight could result in massive, unexpected liabilities. Employees, on the other hand, should get contracts reviewed after any termination to avoid missing out on rightful compensation. And this is the part most people miss. Ontario courts are divided on this legal issue, making it a minefield for HR professionals and business owners both. Should the law evolve to offer clearer guidance and more predictability? Or do these contradictory rulings mean employees and employers alike are caught in a legal guessing game? What's your experience? Have you seen termination clause disputes in practice? Should employers have more power to draft flexible contracts, or is strict protection of employee rights the better path? Share your thoughts and join the conversation. This is one debate that refuses to go away.